Good morning. Happy Deepavali. Mythologically, the Deepavali is being celebrated when Rama returned back along with Sita and Lakshmana after winning the Sri Lankan war. And there are other mythological stories about Naragasura and so many things are there. But North Indian people always celebrate this Deepavali as their first day of their calendar. They start accounts day. So income tax authorities also allowed North Indian people to file their returns commencing from Deepavali day to end the last day of the next that year. So this is the thing. Happy Deepavali. Let us enjoy our bright future with all the entire world. It's all right. Today I am going to discuss and feed you a best judgment wherein several advocates are trembling and courts are trembling whether the evidence being collected by way of Facebook, WhatsApp against the spouses, husband against the wife, wife against the wife, is admissible in evidence or not. This judgment of Madhya Pradesh, Gwalior bench, if you go through the entirety of judgment, you can very well know about the admissibility of evidence which is being collected illegally. That question is most important. Then this judgment is AAR 2025 Madhya Pradesh 132. AAR 2025 Madhya Pradesh 132. Anjali Sharma versus Raman Upadhyaya. Therein the husband, after filing divorce application, says that he is having collection of evidence from WhatsApp of his wife after having installed a device so that her entire WhatsApp messages being immediately forwarded to his cell phone. That way he filed. That petition was allowed. Therefore, wife went to High Court. The High Court has relied AAR 2012 SC 3829, and the most important thing they say, yes, it is a fundamental, that right to privacy is a fundamental right. But at the same time, that will not be absolute and must yield to right to fair trial. So the fair trial is also a fundamental right. Therefore, they uphold the allowing WhatsApp messages being marked. That the court, the division bench, the Madhya Pradesh judge strained to take you section 14 and 20. Section 14 after this the object of the bill when it was introduced was simplify the rule of evidence and procedure so as to enable a family court to deal effectually with a dispute. That section 14. Section 14 must be read with section 20. Act have override effect. That you must go through this independently. Then the question arises, Indian Evidence Act section 5 of the Indian Evidence Act, evidence may be given of facts in issue and relevant facts. That issue was also discussed. Then section 122, communication during marriage. Communication during marriage was also discussed. Then they have discussed multi-number of judgment wherever the issue was obtaining evidence by illegal means. The earlier case, they seems to have obtained some conversation and which was illegal under section 25 of the Telegraph Act. But judges says whatever it may be. Finally, they have discussed the multi-number of judgments of various high courts wherever the personal liberty have been in dilemma. They say there must be three requirements: legality, which postulates the existence of law; need defined in terms of legitimate state aim; and proportionality, which ensures a rational nexus between the objects and means adopted to achieve that. See, after if you go through all these judgment, about producing CDs, all these things. Finally, the judgment has dismissed the application filed by the wife and confirmed the order of the lower court, but given some 5 guidelines. Number 1, evidence is admissible so long as relevant, irrespective of fact how it is collected. Then, merely admitting evidence on record is not proof of a fact in issue. The test of relevance ensures that the right of party to bring evidence to court and thereby to a fair trial is not defeated. The merely because the court allows evidence to be admitted does not mean that the person who has illegally collected such evidence is absolved of liability that may arise whether in civil or criminal or both. Such evidence must be received and treated with caution, circumspection, and rule out the possibility of any kind of tampering. Standard of proof applied by court for authenticity and accuracy of such evidence should be more stringent as compared to other evidence. So, receiving evidence itself is not sufficient. It is the court's duty to appreciate to the relevant fact whether that tantamounts extramarital relationship, everything is open to the lower court. Such a fantastic judgment. So, I do not want to waste time in referring all other judgments. You must go through the judgments and understand this concept of Evidence Act, which we have to work and apply before the family court. Best wishes.